Hi everyone, welcome. Eric Rodebois. We're going to talk about trademarks today. And we're just going to go very general, and I'm going to do a couple more videos later on. And what really made me think of this was a client of mine had an idea for a trademark, and they're not going to be able to do it, so I can go ahead and say it. And the idea for the trademark was House of Croissants, okay? Good name. They make croissants, they sell it, it's a coffee shop. Well, we did a little search, and there is a trademark already registered, Maison du Croissant, and that is French for House of Croissants. And here's the thing, we live in the United States of America, and our laws are written in English, and there is literally a part of the Lanham Act, which controls trademarks, that says if you do anything in a foreign language, like I have a client who's doing stuff with Chinese letters, right? And the trademark is the Chinese letters. It includes the name of whatever it is they do. We had to translate it, and it translated into like food restaurant. And they're like, sorry, dude, you can't trademark food restaurant. And my client's like, but it's unique, it's in Cantonese. Who knows, you know, it's different, we're in the United States. And they're like, yeah, but listen, the rule is you gotta translate the foreign language, so Maison du Croissant does not come as Maison du Croissant, because then we could have Casa de Croissant, right, if we're doing Spanish, or whatever it is in Chinese. And so what they said is anytime you do a foreign mark, you gotta put it in English. Okay, so that's not really the point of this video, but that's a starting point. So I wrote right here, and I'm just gonna say it because I don't want you to read my board, but basically we're gonna start from a spectrum, and we're gonna go, actually I'm gonna do it so you can see it. This is your left, right? It's my right. So this is gonna be automatically trademarkable, it's easy, you're gonna win every time. And those are called inherently distinctive marks. So a mark that like has no other meaning, Kodak. Kodak was a made-up word for camera stuff. And so there was no use of the word Kodak ever before. So it was truly inherently distinctive, and it's easy to register. And so the different types of inherently distinctive, you've got fanciful, that's Kodak. You've got arbitrary, that's Apple to sell computers, right? We're not selling fruit, we're selling computers. I've got suggestive, so Greyhound buses, right? It's like a, you know, you got a dog running, kind of evokes a mental image of transportation, I guess. Speed, but basically you're all in the good category. You're gonna win all those, okay? Then your next category is not inherently distinctive. And this is where you start to have some problems, okay? Not inherently distinctive would be descriptive. Like the example I like is battery extender. You can't trademark battery extender because what does your product do? It extends batteries. So what are you gonna do? Like you're blocking out that name so that anybody else in the world who does what you do can't describe what they do? That's not cool. How about names? A name would be like Charles Schwab. We've all heard of Charles Schwab, right? Financial services, and I guess they've done a lot of marketing, so you hear Charles Schwab, you think of financial services, but the fact is it's a dude's name, and there could be another Charles Schwab out there. I always think of McDonald's. McDonald's restaurant, right? There was a McDonald's restaurant selling hamburgers. There could have just as easily in one town over been a McDonald's restaurant selling, I don't know, barbecue. It's just the name. Third one is geographical, such as Sonoma wines. Right, so you're going to trademark Sonoma wines, and now nobody else in Sonoma, because Sonoma is actually a pretty big valley, nobody else in Sonoma growing grapes and making wine can call it that. So all of those things need to be able to demonstrate, and these are all the ones that are not inherently distinctive. These all have to be able to demonstrate a secondary meaning. And the typical rule of thumb is you have to have been in business using that mark for at least 5 years. Because then you can go and say, hey, Sonoma wines doesn't just mean the valley, Sonoma. People now associate Sonoma wines with our vineyard. People associate Charles Schwab with our financial services. People associate or McDonald's restaurant with our hamburgers. And so you have to demonstrate secondary meaning, which means it's more work for the lawyers. So a client comes into me and says, hey, I want to trademark Kodak or the equivalent, and I'm like, all right, well, cool. And I'm going to be like, that's going to be pretty easy. Somebody comes in and they say, I want to trademark McDonald's restaurant. I'm like, ooh, that's going to be tough. How long have you been in business? You know, how can we demonstrate that you've attained a level of notoriety beyond just your name? Which is possible, by the way. I can win those arguments. And the space in between is the gray area where lawyers have to be creative, where a very conservative trademark officer might deny us because they tend to stay away from being risky. That's also one of the problems with the trademark office is you talk to 3 trademark examining attorneys and ask them the same question, you might get 3 different answers. Not cool. And then the last one, just all the way over here on the left side of your spectrum, is generic. And just a generic word, like cafe. You can't trademark cafe. You can't trademark restaurant. You can't trademark grocery store because that's just generically describing the activity. So remember, over here we've got inherently distinctive, right here in the middle we got not inherently distinctive, and over here on the left we got generic. Have fun registering a trademark, protecting your brands.